Good morning, ma'am. Are you Glenda Willilifford and Mr. Rojas?
And boom, 5 seconds in and we already have the classic "there wasn't me" defense. If courtroom dramas have taught us anything, it's that whenever someone starts with this line, it usually was. But let's see if the evidence backs them into a corner.
Will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Willilifford, in cause number 24 DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
Judge, we could read to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you...
Quick legal breakdown: when you're on deferred probation, the court hasn't officially convicted you yet. But violate it, even once, and the state can yank that second chance faster than you can spell tetrahydronaban. And here? We're not looking at one violation, we're looking at a whole sampler platter.
You provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true? And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Speak up, please.
Yes.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding? And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by...
This right here is what lawyers call a gracious warning. Instead of revoking probation and sending her to prison, the judge is opting for rehab, structure, and extra time. Translation: I'm giving you rope, don't hang yourself with it. Judges don't extend probation out of pettiness, they do it so the defendant can actually complete the required programs.
Some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Willilifford is not competent?
Okay.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage.
Huge moment. When a judge says there will not be a third chance, that's not courtroom poetry, that's legal reality. She's facing a 20-year max sentence. This is the last off-ramp before the highway called state prison. The tension in the room? You can feel it.
Of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for explaining the real reason I was doing marijuana. I was because of my image never is. And I will promise you on Jesus' happy golden soul that I will never touch this shit again. Let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I feel so right now. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I really was trying to.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Went better than I thought.
Really?
This one, no, it's right now on camera.
Oh.
Literally about it now.
You just never know. What-
This is what? Everyone's over.
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said frigate.
Well,
You know what she meant. I know what she meant.